before I turn to Professor Gallagher, let me just remind the audience, you're welcome to send questions directly to me over the chat function, which I will ask the speakers at the end. So if you have any questions, please feel free to send them to me via the Zoom chat function. Okay, so let me now turn over to my colleague, Professor Steve Gallagher, for his presentation on the law of unjust enrichment and equity. Professor Gallagher, please.
Thank you very much, Rian. And I need to upload some slides, so if you can just bear with me where I share my slides. Unfortunately, as my former students who are here know, I'm a slave to PowerPoint, and also PowerPoint is useful here because the Dean has threatened me that I have to keep to time. So the PowerPoint hopefully will keep me to time. It's a great honor to follow Professor Martinek, and I'd like to thank him again for last week when he was our keynote speaker at our legal education conference. So it's been great listening to him last week and listening to him this afternoon as well. Good afternoon to everyone. I'll be talking about the law of unjust enrichment and equity, which of course Professor Martinek has already touched upon. What I wanted to do is I'll give a very brief introduction, which is just a little bit about my own prejudice in this particular area. Then I'll talk about what is unjust enrichment in common law, what is equity, and then if unjust enrichment and equity do interrelate, and of course bearing in mind what Professor Martinek has just been saying about unjust enrichment and equity, and some concluding observations. So let me start with a brief sort of introduction, and this is more of a sort of a declaration of my own prejudice here. Many of you will have read Professor Burrows, now Lord Burrows' article last year in defense of unjust enrichment, where he noted a significant skepticism about the utility of recognizing a law of unjust enrichment. And I think we've already heard that from the Dean as well. So I have to share with you all that I have a skepticism about the utility of recognizing a law of unjust enrichment in the common law, particularly because of its basis in a coherent, unified law of restitution. And of course, one of those reasons why perhaps I am prejudiced against this, I think was touched on by the judge and legal academic from Australia, Keith Mason, in his article, where he talked about the problem with some people when they consider unjust enrichment and restitution is, of course, their concerns, particularly if they teach subjects like equity, like me, that perhaps their area of law will be borrowed from to such an extent that there is actually a hostile takeover going on. So I think bear that in mind with my comments now. So let's think a little bit about what unjust enrichment is. And of course, Professor Martinek has already started to talk about this. Of course, unjust enrichment has been used in a broad term in common law cases for 100 plus years. But really, we're talking about it today as a cause of action, or as it's often identified as a cause of action coming from the case of Lipkin, Gorman and Karpnali, the House of Lords judgment back in 1991. Lord Gough, who of course had been writing extrajudicially about unjust enrichment and restitution from the 1960s, used this particular case, perhaps not the best case to actually use, to develop his law of unjust enrichment, which I think was part of his quest for a unified law of restitution, which probably is why I'm a little bit against the whole thing. I had a former colleague who used to teach our course on unjust enrichment, who managed to convince me that at least it did exist now in the common law as a cause of action, as the newest cause of action at common law. So that's why it's an interesting thing to talk about, because we have this very sort of denial of its existence, then a sort of begrudging acceptance by many people that it does exist in the common law today. So that makes it an interesting topic. It makes it a very interesting topic for all of us as academics, particularly for practicing lawyers as well, because if there's uncertainty, well, I'll leave that to the end, and we'll talk about how uncertainty can be good for the law and for lawyers, of course. I should also say that possibly this judgment and the concept of unjust enrichment is possibly the only lasting legacy of this search for a law of restitution in the common law. So Professor Martinek referred to a 4-question approach to unjust enrichment. I prefer Keith Mason's 5-question approach. I agree that it's very difficult to use these, but just to give an idea of what unjust enrichment is about in common law, Keith Mason identifies 5 questions. Was the defendant enriched? Was the enrichment at the plaintiff's expense? Was it unjust according to the categories developed in the case law? Do any restitutionary or other defences available apply? What remedies are available and appropriate? And I think this is useful because particularly number 3, the question 3 there, the categories. And again, Professor Martin touched on this. At common law, we require some form of unjust factor. And these are the categories that are usually identified: money paid under void or unenforceable contracts, payments under mistake of fact or law, payments on a consideration that fails, contributions and recoupment claims, restitutionary claims against the revenue, and non-contractual subrogation. These were identified by Keith Mason. Also, his question 4, do any restitutionary or other defences available apply, also leads us into the defence that was specifically identified in Lipkin-Gorman by Lord Gough to a claim for unjust enrichment, which of course is the change of position defence. And here we have the identification of the principle by Lord Justice Clark back in 2003 in the Court of Appeal in England. The essential question for the court when considering the defence of change of position is whether on the facts of a particular case it would in all the circumstances be inequitable or unconscionable, and thus unjust to allow the recipient of the money paid under a mistake of fact to deny restitution to the payer. The change of position defence works on the basis that when the court is considering whether the monies should be repaid by the defendant, they will consider the fact that if the defendant has acted in good faith, has received the funds believing he is entitled to them, and has then used them in such a way as to make him repay the funds now, would put him in a position that he was worse off than when he originally received the funds, well, then he may be able to rely on this change of position defence. But my very phrasing of that and the use of words like inequitable or unconscionable are, I think, what concern people about where unjust enrichment fits in the common law, because this is very much a sort of an equitable concept. And of course, to explain a bit more about equity, I need to tell you a little bit about what equity is. Now, the Dean has told me I have to explain equity in 2 slides. So 800 years of equity, I'm afraid I've got to use 4 slides. I had to go to 4 slides. So generally, most legal systems have a concept of equity. They need a concept of equity. Professor Martinek was touching on this as well. This is that general idea that you can't design a system of laws to deal with every eventuality. So you need some flexibility. And that's what equity is all about. And most legal systems have that concept. However, at common law, of course, the common law developed equity in a very strange way. The common law developed equity so that it became the province of a separate court, the Court of Chancery, the Court of the Chancellor. And it became a separate body of decisions, the decisions of the chancellors. And these decisions, originally based upon the king's prerogative, his ability of the king and then his chancellor to actually speak above the courts of the king, this was the important basis of equity in the common law. And it was decided according to conscience, and it was always considered to be discretionary. The most important thing about, of course, equity was the development of these powerful remedies that the common law did not have. So the common law, the remedy usually would be damages, a money remedy. In equity, of course, we have the injunction. We have the trust as a remedy. We have orders for specific performance. If money isn't good enough, then exceptionally you get the remedies of equity, which give you more. So equity became extremely successful as a separate jurisdiction. And that was problematic. There have been huge disputes and fights between the common law and equity, between the common lawyers and the lawyers of chancery. And of course, they focused on the usual things: issues of jurisdiction, issues of authority, and of course, most importantly, money, fees. Equity chancery was so successful that the common lawyers were losing business. Eventually, of course, after numerous disputes, we had what was meant to be the settlement of this issue of the dispute between equity and the common law. And that, of course, was our Judicature Acts, which fused the administration of equity and the common law in one court, a court which could administer both common law and equity. The principles, the rules, the remedies of both could be administered by one court. However, we still have ongoing disputes. We still have ongoing disputes about whether equity and the common law are really fused, about whether they have come together as one body of law, about whether an action which is at common law can actually result in a remedy from equity. And that's the basis, really, of the argument of those who put forward the law of restitution. And they tried to borrow from all areas of the law to form a unified, coherent law of restitution. And that's still a sort of battle, a fight that's going on. And it waxes and it wanes over the years, but very much going on. So today, to consider where equity fits in the common law, I have to say something that probably those who taught me about equity would not agree with. I think equity has always been part of the common law. It always works with the common law. So how do we use equity in the common law? Well, the first and most important principle to always remember about equity is that equity follows the law. Equity is some exceptional justice. So equity follows the law. But then if there is a gap in the common law, or if there is some unconscionability which the common law can't deal with, or if the rigid application of the law would be inequitable, then equity may intervene. Because equity will not suffer a wrong to be without a remedy. And if there is a conflict between the common law and equity, equity will prevail. But that's only if there is a problem with the common law. The other thing to remember, of course, as well, is equity is always discretionary. We may go to equity, and then we may find that equity will not assist us as well. So this is the sort of the complex idea of equity within the common law. Why does this affect us with regard to unjust enrichment? Because those proponents of unjust enrichment in the common law have always stressed it is a common law form of action. Well, of course, Professor Martinek touched on this again. The problem comes from the words of a judge 260 years ago. And this is where we have to think about unjust enrichment and equity. And those are the words of Lord Mansfield in Moses and McFarlane. So Lord Mansfield in Moses and McFarlane used terms to describe his extension into quasi-contract. He used the words equity, equitable action, and famously ex aequo e bono. And these have already been referred to by Professor Martinek, but these words have caused concern with those who are arguing that unjust enrichment is a common law action, because, of course, they often refer to this case as being the foundation for the modern law of unjust enrichment. So the question really is, when Lord Mansfield was talking about equity here, was he talking about equity with a small e or equity with a capital E? Was he really referring to chancery equity, or was he just talking about a general sort of concept? And again, I think Professor Martinek has already talked about this. Those who are in favour of a law of unjust enrichment, a law of restitution, including the late Peter Burke's, were very firmly of the opinion that Lord Mansfield's reference to equity here was very much with a small e. So famously, in his book, Law of Unjust Enrichment, Peter Burke's referred to the fact that Mansfield's echo of the Roman aequitas in Moses and McFarlane is being made to suggest either that he was referring to equity in the sense of chancery law, or if he was not, that his aequitas was and is one and the same as chancery's equity. And of course, Burke's was very much against this. He said, no, that's not the point. It's a general principle that he was referring to, not the chancery jurisdiction. However, we have to remember that, well, Lord Mansfield was, as it says there, well known for his importation of principles of equity in the common law. We have to remember that Lord Mansfield was a Scot. He was well versed in Roman law, in civilian law. He had practiced at the Chancery Bar. He was a member of Lincoln's Inn. He was a Chancery lawyer who became a common lawyer, the Chief Justice. The legal historian, Baker, quoted Lord Eldon in his book, where Lord Eldon had said, Lord Mansfield never liked the common law so much as when it was like equity. And there are numerous judgments of Lord Mansfield's where he's introduced elements of equity into the common law. What we should remember, again, is that today we are looking at Lord Mansfield's judgment with the eyes of 21st century lawyers, considering equity as it is today. And Mason, in his article, referred to this. He said, we should remember that 18th century chancery law was still in its early childbearing stage. This was the early modern development of equity. And anyone's reference to equity in 1760s are not to be tested according to the exacting standards of a 21st century equity treatise. So it's important that we think of this. So it's much better to consider the more recent seminal case of Lipkin-Gorman and consider the terms that were used there. Lord Gough, when he was actually developing the concept of unjust enrichment in the common law, referred to another of Lord Mansfield's judgments, Clark and Shee and Johnson. And he referred to this case because the plaintiffs had put this case forward as analogous with their own case. And Lord Gough said, this is a liberal action in the nature of a bill in equity. And if under the circumstances of the case it appears that the defendant cannot in conscience retain what is the subject matter of it, the plaintiff may well support this action. Again, we get the use of the word equity, we get reference to conscience, very much equitable concepts. And that's, again, one of the issues that has really dogged the development of unjust enrichment in the common law. Lord Gough also referred to the change of position defence and said that given that it is not inequitable to require the casino to repay to the plaintiff the amount of the bets in full, where no winnings have been paid, it would, in the circumstances I've just described, be inequitable, in my opinion, to require the casino to repay to the plaintiff more than one half of his money. The basis of the change of position defence is it would be inequitable. Now, again, as soon as we start to hear words like inequitable, we start thinking of equity. And we should remember that Lord Gough was very keen that unjust enrichment should have nothing to do with equity, because he does carry on and say the recovery of money and restitution is not, as a general rule, a matter of discretion for the court. A claim to recover money at common law is made as a matter of right, and even though the underlying principle of recovery is the principle of unjust enrichment, nevertheless, where recovery is denied, it is denied on the basis of legal principle. Lord Gough and many commentators on the law of restitution and the law of unjust enrichment were very careful to try and steer away from equitable principles. They wanted their law of restitution, their law of unjust enrichment, to be very certain. That was the important things. They didn't want the discretion of equity. Really, I think this particular quote possibly illustrates what Professor Martinek was referring to as the groundless anxiety that they might be leaving a back door open for arbitrary judgments. I think this is their concern about this idea of discretion. Anyway, some concluding remarks then generally on how equity and the common law fits together. I'm not too sure I can completely agree with Professor Martinek. Professor Martinek said that unjust enrichment is in no sense based in equity. I think in common law, the unfortunate thing is that our development of unjust enrichment has been phrased in these equitable terms at times. And that's what's led to the uncertainty here. It's really made this area of the law, well, there's no other way to describe it than at common law, unjust enrichment is very messy. And that's why people get very concerned about this, because of the use of these equitable terms. No matter the protests, and even protests that might come from me at times, I think that our unjust enrichment seems to have a basis in equity in the way it's been phrased. And even the defence to it, the change of position defence, seems to, whatever Lord Gough was to say, be based on equitable principles. Peter Burke's, others, they dislike the discretion of equity. But of course, there now is a problem with how we develop unjust enrichment within the common law, because many are trying to develop unjust enrichment, to take it further, to mean that it's not just another name for money had and received, that it actually becomes some form of common law cause of action in its own right, that it becomes more powerful than just something to recover money, that it has other remedies available to it. And in doing so, of course, they keep on straying into equity because they want the powerful remedies of equity. If people are concerned, by the way, about the messiness of this area of the law, I should say to you that, as I say to my students, it's an interesting area of the law. The very sort of messiness of it makes it very interesting to consider it, which is why this conference is such a great thing. And also, it's got to be very good for practitioners, because if we want to blame anyone for the problems with this area of the law, let's blame Lord Mansfield, because he's been blamed many times before. And I always remember that famous toast that was given by lawyers back in the day. The sergeants in their inn in 1756 gave a very famous toast to Lord Mansfield, to the glorious uncertainty of the law. Why? Because Mansfield had recently given a series of decisions which had imported ideas from civilian jurisdictions, which had overruled many traditional principles of the common law, and which, of course, Mr. Wilbraham, who gave the toast, said will lead to much more business for all of us. So I put up some references just there to some of the things I've mentioned. Thank you very much, and I look forward to further discussion later on.
Okay, thank you very much, Professor Gallagher, for that tour of equity and unjust enrichment in the common law. Especially enjoyed the critical end about Lord Mansfield. Much of my own work has been taking down not taking down is putting it strongly, but criticizing high-profile judges who sometimes godlike stature. So I appreciate that